Good morning and good afternoon, everyone. I'm Fred Buret, Blockchain Investigations Manager at Recoveris, and welcome to another session of our series, Digital Asset Recovery Around the World. Throughout this series, we speak with practitioners who are at the forefront of digital asset disputes, investigation, and recovery efforts in their respective jurisdiction. Our goal is to move beyond theory and understand what is actually happening on the ground, the cases being encountered, the legal tools available locally, and the practical realities of asset recovery. Today's session will be an informal interview-style discussion of around 30 minutes, followed by a live Q&A. Please feel free to post your questions in the chat throughout the session, and we will do our best to cover them at the end. As always, a quick disclaimer, nothing discussed today constitutes legal or financial advice. This webinar takes us to Ukraine. The jurisdiction offers unique insights into digital assets being used, regulated, traced, and recovered in some of the most challenging circumstances imaginable. I'm delighted to be joined by Dmytro Marchukov, a fellow member of ICC FraudNet and senior partner at Impacta Law, who will share his perspective on Ukraine's evolving digital asset landscape, including practical experience from matters involving crypto. Dmytro, thank you very much for joining us. Perhaps you could start by introducing yourself and tell us a bit more about your practice.
Yeah, thank you, Fred. Thanks for inviting me to the webinar and for given me the reason to wear the smart suit on the Friday home office, at least the upper parts of the smart suit. Yeah, I have been practicing disputes for over 20 years, and because Ukraine is not as huge market as it is in London, in the States, in France, and in many other countries. So I can't really specialize in, for instance, aviation insurance disputes. So I have been doing more or less everything which I like, everything between like contentious inheritance and geopolitical investment arbitrations and all sorts of contentious matters in between. And in between, this includes also some crypto disputes. I should confess that like at the moment I'm not working on any of the crypto disputes, but until recently and for several years it consumed a really significant chunk of my workload.
Okay, interesting. I'm looking forward to hear a bit more about this. So as the usual schedule agenda that we have, we like to hear a bit more about what you see locally, how crypto is used first, what kind of services are operating there, how people are using crypto, things that you're seeing on the ground, and how it translates also with the recent events since the beginning of the war in 2021.
True. Well, crypto has become a notable issue within sort of like shadow economy, I would say, but not only shadow economy. Some like public officials are declaring in their like property declarations. So it's not only that, but well, I think in this sense, Ukraine is not much different from various other countries. The digital assets is the concept that is known and recognized by the Ukrainian law. We have had the law on digital assets since early 2022, and it has never entered into force still, because our MPs need to introduce certain amendments into the tax code, essentially regarding taxation of the gains. And I don't want to blame anyone, but seems like they're thinking about themselves by delaying all this. And yeah, the law which we have is not really aligned with the EU MiCA regulation, but while this law has not entered into force, we already have like another draft law which is more aligned with the EU MiCA regulation, and yeah, hopefully it will be adopted in some foreseeable future. And yeah, other than that, well, this means that we have like no Ukrainian licensed VASPs, and still we have yeah, many individuals who like own cryptocurrency, who transfer it, who purchase it, who exchange it, and we have decent ones who declare this in their tax declaration if they're obliged to. We have decent ones who do not declare, and we of course have many fraudsters as well, and which makes at least my life more entertaining as a lawyer and as a recovery specialist. We have like mining is kind of like booming, I would say, but of course, when we had the severe power cuts because of the Russian missile attacks, yeah, it prejudiced. We now have 2 mining plants built close to one of the nuclear power stations, and one of them is actually PPP, like public-private partnership. So okay, yeah, we are like moving in some direction, but maybe not in a very consistent way on this.
But there's some initiatives that are quite advanced, as you mentioned.
Yeah, it was something.
You said that the apparition of a shadow economy, is it in response of, I don't know, banking limitations due to the war, or like fear that uncertainties around having a bank account when crypto allows you to have it directly on your phone and it's more mobile, it could move with you as the war is evolving? Is it something that's, I don't know, it's maybe less easy to put in statistics, but maybe in the day-to-day life, it's something that appears. I don't know.
It's everything, Fred. I think in this sense, Ukraine is not very much unique. We all know that yeah, crypto has been like the border of the like dark world and the light world, and well, we also know Monero, which is like behind this border very often, and yeah, it is only that in Ukraine it has its twist, unfortunately, because since 2022 we have really strict currency control restrictions imposed by our central bank because of the war again, and yeah, these restrictions are understandable to prevent outflow of the currency from Ukraine, especially with like some 6 or 8 million of Ukrainians being outside Ukraine, but many of them earning still in the country. So these restrictions are understandable, but people are creative. They are considering various other options, and yeah, this way, like owning crypto and using it has become one of the ways. I cannot say it's like widespread, but it's definitely there to like circumvent, perhaps not to breach, but at least to circumvent these restrictions.
It's easier for the common folks than opening an account abroad, I guess.
Oh yeah.
Actually, I have to say, I don't remember if we discussed this before, but one of my cases, my very first recovery actually, was supposedly from a Ukraine elderly woman, an account. The lawyer I was working with had the account holder on the phone as the exchange kind of removed themselves from the picture and said, negotiate between each other. And the person on the phone on the other side was definitely not an elderly woman, but with an accent that could be Ukrainian. We're not sure.
True. Or maybe she just had a very young voice.
Yeah.
Well, this sounds very much like a Ukrainian story.
Yeah, it could be from another country as well. We're not sure at all. It's, they went for settlements. If we move on to the different legal tools, can you expand a bit more of like how it applies to digital assets, especially, but how would you go about the recovery of an individual who has lost some funds to an investment scam, for example? What kind of tools is available for them in Ukraine?
Yeah, well, I cannot say that we have like really specialized tools when it comes to the crypto assets. Well, maybe use of chainalysis is something that applies in most of the investigations, and other than that, the civil tools, the criminal tools, mostly criminal actually. What we have seen, in the in such type of matters, but to a big extent, this is because we are civil law jurisdiction. We are not common law. We do not have civil fraud. So fraud in Ukraine is criminal, and then there are issues with money laundering and tax evasion. So it sort of like automatically brings us into the criminal law part of the legislation rather than civil law. And we have a specialized unit in the police, which is called cyber police. They were created well before crypto has become a trend. So they were mostly into like cybercrime, hacking, and all that kind of stuff. In the past years, they have become really specialized in crypto. There are some brilliant guys working there, and some of them are even too brilliant. And I know that they are trying to establish some working relations with the crypto exchanges, and here I'm talking not about the Ukrainian ones, because we do not have licensed Ukrainian VASPs, but with the foreign, with the global ones. And we see that sometimes the cooperation goes quite efficient. For instance, on one of my matters, I saw very generous disclosure by one of the crypto exchanges, like starting from the AML file on the holder of the account and down to the various transactions. And also I saw the case. One of the examples when the crypto exchange froze the account without, like, just upon request of the Ukrainian authorities. So it wasn't a proper freezing order. And something similar I saw on another case when a proper freezing order was cancelled. And then I saw communication between the Ukrainian authorities and the crypto exchange, when the authorities were saying, like, can you please wait with unblocking the crypto assets until we get the new freezing order. And this is what happened. But yeah, we also understand that crypto exchanges, in their rules, in their terms and conditions, they always have lots of reservations which allow them to block the assets. And so the cooperation of the cyber police with VASPs is something that we see. I cannot say that it is efficient all the time, because as in any country, our law enforcement authorities are overloaded. And one of the tools, if I may call it, which we have used, is when we have a foreign client we can also try to engage the respective embassy, not for some like preferential treatment, but just for the proper attention by our authorities. Although I think in this context, proper attention already qualifies as a preferential treatment.
Yeah, that's I think that's the issue we have in every jurisdiction on our cases across all jurisdiction, is that once you send the information, the collaboration is a bit one way. I think the fact that you're able to deal with a prosecutor directly, and then they run their own investigations, of course, but provide them with as much information as possible on the location of the assets or where they have been sent to, and really prepare the work so that they just have to review and then execute some easy action. That's been the key for us to get something to happen. But then also, if the funds have been sent to a specific exchange, and this I think applies in the traditional world as well, is that they get some information. Do you get them to share this information with them, the disclosure of the account? Is it something that's is happening in Ukraine, or is it once the ball has been given to the police, it's their investigation and they run with it, or they just and then it's about getting some updates at some point, but we don't get any more information, or like the investigation stops on our sides. Is it a bit similar in
yeah, this is the similar set of problems which you have identified, Fred, and this is one of the reasons why we try to avoid criminal route. But as I said, sometimes you cannot truly avoid it, and there are also various tools within the criminal route which are not available within the civil one. So you sort of like hand your case into the hands of the law enforcement, and then you actually hand yourself into their hands. And but they do disclose information, because sometimes it's like something we need to provide them with. Sometimes we need some information from them, so it's like caring and sharing. And also, if we are working for the victim, so like as attorneys of the victim, we are allowed to see parts of the criminal file. And so it's always about negotiating, and also if we want to use the findings of the pretrial investigation somewhere else, we have to seek the permission of the investigator or the prosecutor. And this is something, another issue to negotiate, because they always want to give such waiver as narrow as possible, and with some undertakings. But generally, it's doable. It's just a bit painful process all the time.
Yeah. You mentioned at the beginning that you cover a wide range of type of cases, because asset recovery is I think this is the interesting part of asset recovery, is that the context is always a bit different, and then I guess it impacts on the tools that you can use on your side, civil or criminal. But when you find that there is some crypto, what type of cases is it, and how do you is there any example you want to share?
From my own examples, we have had one arbitration against one of the crypto exchanges. So we were acting for the holder of the account. It is only that the arbitration is confidential, and I do not think that I can disclose. But ultimately, the arbitration was settled, and it essentially had to do with the crypto exchange being overly zealous with respect to the account holder, and this was settled, and the client got everything that he needed, but yeah, the question, because of the volatility of the cryptocurrency, yeah, we need to calculate, maybe he lost something, some big amounts, or maybe he earned some big amounts, but yeah, at least if converted into one of the fiat currencies. And other than that, mostly criminal proceedings. Of course, it can be in the civil world as well, when like the debt, some like contractual or non-contractual, is owed by someone, and the creditor is looking for the assets, and comes to the likes of Recoveris, and then you find some crypto for them rather than any other assets, because it may well be that the assets may be alienated and dissipated, but not the virtual ones. And yeah, essentially, yeah, I haven't, like in my practice, I haven't had an example when we really were able to like sell the crypto at the auction initiated by the bailiff, but we were close to that actually, but then like the case was resolved in another way, and I was even talking to one of the valuation experts in Ukraine, like a very experienced one with whom we have worked like for 15 years on like valuating, doing valuations of like all sorts of assets, and he confirmed to us that he would be able to do the valuation for the cryptocurrency as well, essentially by applying the conversion rate or double conversion rate, first into dollars, then into the Ukrainian currency. But volatility is the issue, of course, because even if he has essentially we have the valuation report from him today, then the auction itself will be in like in the best case scenario a couple of weeks from now, and it may be whatever.
That could make a big difference. And is there any guidance from the courts, or like just the local law, on how is it at the time of the loss, is it at the time of the trial, or is it at the time of where like whatever price there is? I refer to some cases I think that happened in Singapore, and I worked on one that settled in the UK, where we had to be a bit more complex than this because of the volatility. We had to demonstrate that the value was that we were pushing for was something that they could have expected to get. So because it was a lot of tokens, it would have taken them time to sell these tokens without impacting the price, and we had to use the volume and the pricing of the different exchanges that they were actually using, and going back in this story using data that you can't really rely on, because a lot of it may be inflated or not. And so yeah, it brings questions that are quite interesting. But yeah, is there any guidance locally on how to deal with very volatile assets in general, or is it on a case-by-case basis, and you push the scenario that's around your clients in a way?
Yeah, well, generally there are several moments involved. So first, when you actually get the judgment against the debtor or the fraudster, and yeah, typically you get a monetary judgment, and then yeah, like no volatility should be involved there. But yeah, if crypto is stolen, then like volatility is involved, and yeah, I just do not think that yeah, there's any guidance. Like when you file the lawsuit, you try to convert, but it also depends whether you're seeking the damages which need to be converted, or whether you seek the return of the assets. And yeah, depends on what happened, what the claims are. under which law they are filed. And then another moment is when the crypto is frozen already and ready to be auctioned. And although there are various practical issues involved about how this may happen, like in a compulsory way, but at least the valuation should be made ahead of the auction and not not taken into account any other moment in time. But as I said, even at that moment, even if we have the valuation as of today, I don't know, 12:28 Kiev time, given the volatility, then by the time the auction is held, it may be different. But well, it's the auction, so the buyer decides based on the price at that moment. And we actually once working for our client prevented the auction from being made, but it's not as if we worked for a misunderstood person. It was really the guy who was I think not even persecuted, but persecuted by our authorities, and this way we helped him. But we were curious to see how in a compulsory way they were going to sell the crypto, or they were going to sell the title to it. It was interesting, but we still prevented that.
Well done. Thank you very much for sharing your insights on the practical cases. My last question is the crystal ball. What do you feel is gonna happen? You mentioned that there's some regulation coming. There's been delayed, but it will be coming at one point. It's gonna impact the way you do asset recovery for this type of assets. Is it I'll leave it open to you to decide. But anything on future trends or that in this sector?
Sorry, Fred, I'm reading the questions, but
no problem. We'll pick them up after. I would suggest to if there's any vision that you have for the sector, that future trends, or that you think is it gonna be easier? Is it not gonna be easier? Or what's gonna change, especially with the incoming regulation in Ukraine?
Well, first of all, we're waiting for the incoming regulation. And so we will have our own VASPs, I would assume, and this should make things more interesting for us as the Ukrainian law practitioners, but at the same time maybe less interesting, because now all the matters of this type on which we have been working are cross-border because of the VASPs being somewhere. And but even if we have our own Ukrainian licensed VASPs, I hardly imagine that they would be purely domestic, because crypto itself, everything around it is so global and international, with transfers made between the borders, even if the virtual borders. And one more thing is that we now have a decent number of designated individuals, and including some Ukrainian guys, and with their funds blocked, assets blocked, and so it's not the same in theory as freezing the assets, but pretty much the same, or at least there are limitations with banks and so on. And now breach and circumvention of sanctions per se is not criminalized. There's a draft bill now, and it may be criminalized soon, and it should be, I believe. And I think this should bring the additional chunk of work for the Ukrainian lawyers. I would assume that primarily on the defense side, because on the other side there would be really prosecution authorities acting for the states rather than some victims.
Interesting. So more work for you incoming.
Even more work.
Even more work. Shall we pick up the questions? I think they are three. Thank you very much for participating. It's always a pleasure to have live questions. So a question from Civic Data. I understand so most of the funds are usually going to Chinese money laundering network, and it's something that we observe as well. So it can take the form. Usually, I don't know, Civic, if it's what you mentioned there, but that the funds are going to basically very active clusters of addresses on Tron usually, and it makes the tracing doesn't make any more sense really, and it's usually where we stop, and because it's these OTC over-the-counter services that are operating cash out services, meeting the need of local Chinese for crypto, and people with dirty crypto or tainted crypto, I would say, stolen funds, and try to cash out locally. So yeah, it's very challenging. Of course, you can try to keep on tracing and recover the funds from individuals who are buying this crypto from these services, but there's a risk to it that they will have a legitimate right to keep their assets, and there's also the risk that they will be in jurisdiction where there's really not much you can do. But yeah, from a law enforcement perspective, I think you may have more powers than just a private investigator to go after these funds. But yeah.
Well, I think MLAT assistance is one of the tools, not very efficient and time-consuming, but yeah, at least it is there. And also, even with MLAT assistance, we would still engage the local lawyers for the jurisdiction where the crypto exchanges is registered. Or still, in Ukraine, for instance, I know that at least one crypto exchange provides Ukrainian authorities with the information about Ukrainian account holders.
Okay.
So I think that depends. Typically one has to have a map of who is in which jurisdiction, and then ask lawyers there. Because on these cross-border matters, we do not work alone as Ukrainian lawyers, because we also have our own limitations and licenses, and also liability insurance does not cover advice on any law other than Ukrainian.
Yeah. Shall we go to the next question from Dmytro Marchukov? He's asking if which jurisdiction offers the strongest legal mechanism for obtaining disclosure regarding crypto wallet ownership. So I guess on accounts at exchanges or tracing crypto assets. I think there's different response to it. There's not one that is better than others. I'm myself based in the UK, so I'm a bit biased. I will say that there are tools here, civil tools that enables clients from anywhere in the world to come here if their case have just the slightest link to the UK, and so it enables you to bypass the limitation of law enforcement and really lead your case and for the recovery of your funds. Of course, it costs because you have to apply for court orders and then make sure that it's enforceable in the local jurisdiction. But that's where my expertise as a non-lawyer stops. But yeah, that's it. And I don't know if you want to say anything, Dmytro, on this. before?
Well, to be honest, I never considered like a ranking of jurisdictions, just because, well, whatever case we have, we just go where we have to go. And yeah, my impression has been that like Singapore and Hong Kong is like at least the jurisdictions where, yeah, we could obtain something more. And although, as I said, in Ukraine we had some like really generous disclosures as well. Yeah, other than that, I think it also depends on like on the particular case, on the set of facts, on the law enforcement authority or a judge you're dealing with. Yeah, so really hard to say.
Yeah. Yeah, overall, if local law enforcement understands what crypto tracing is, and how the recovery may work, having them involved is by far the most cost-effective way of leading the case. Yeah, we've got really good experience with Hong Kong and Singapore law enforcement as well on our cases. Have you had practical experience handling disputes or enforcement proceedings in such jurisdictions? So I think we covered that. And I think the last question is for you from Victoria in Australia.
Yeah. So good evening, Victoria. Yeah. And the minimum practical amount. Oh yeah, that's always an issue. Yeah, my instinct says the more the merrier. Well, of course, first of all for the fraudster, but also for the lawyers and the asset recovery specialists like you, Fred. But yeah, I think it depends on like when the fraud was uncovered, how much time has passed, and what has happened after that. Because, for instance, if it is like purely within Ukraine with like not long chain involved of like transfers, bridges, and mixers, then perhaps even like $100,000 equivalent would be okay, worth this like small crusade. But if the situation is overly complicated, perhaps with money law involved and with various transfers across the jurisdictions, maybe even 1 million would be too small amount to throw good money after bed. But at least for some like for some scoping exercise, just to understand the chances, I don't think that any amount is small.
Yeah, very good summary for the end. I see someone is typing, but I think we'll close to respect the time of everyone. Oh, okay. Well, thank you very much, Victoria. I think we'll close here because we're nearly at the end of the 40 minutes allocated. So yeah, a big thank you to you, Dmytro, for joining and sharing your insights, and to everyone who joined us today, especially the questions. Yeah, please keep an eye on our LinkedIn page for the next episode. The next session planned is lined up on the 9th of June, and we are heading to the United States with another ICC FraudNet member, Secure Law. So I'm really excited to keep on unpacking how digital asset recovery works across different jurisdictions. Thank you for tuning in, and thank you again, Dmytro, for your insights. And we hope to see you at the next one. Bye-bye, everyone.
Yeah, thank you, Fred. Thank you, everyone, and enjoy the weekend. Take care.
Bye.